So, it is a great pleasure to have David McCraw here to give the first of a series of interviews for the platform of Freedom of Speech and Democracy. David McCraw is the Vice President and Deputy General Counsel of the New York Times Company and an adjunct professor at the NYU School of Law. He has been working for the past 16 years as the New York Times top newsroom lawyer, and he has been the newspaper's principal legal advisor on many important and impactful stories, including the WikiLeaks and Edward Snowden disclosures. So thank you so much,
Thank you,
Professor Edward, for being here today. For us to kick off, I would like to ask what kind of legal issues, or to what kind of legal issues you devote the most part of your time working as the principal lawyer at the New York Times? What are the main vulnerabilities the New York Times and its lawyers face today when trying to bring newsworthy information, not only to the American public, but also to populations around the world?
The primary issue that we deal with as a legal department for the newsroom is freedom of information. We spend a lot of time figuring out how to help reporters get information from government. We litigate a lot of cases over freedom of information where we sue a government agency. We're still concerned with the issue of libel and defamation, and we will do review of stories for legal issues before they're published. But in the United States, the law has become so protective of publishers that it is a lesser concern than it was, say, 40 years ago. We actually have relatively few libel cases. It's important that we do legal review of stories all the same. We don't want to have unnecessary litigation. I think we also help by encouraging reporters to double check and make sure stories are right, and a legal review does that. So we remain concerned about libel, even if it isn't as big an issue as it once was. We're also helping reporters on news gathering issues, that we want to make sure that when reporters go out and get stories, they don't inadvertently violate the law, that they are doing what they can to make sure that their methods of getting information are legal. There's a variety of other issues we come across. An occasional copyright issue will come up. There will be an occasional time when a government agency or a private party will subpoena a reporter for his or her notes or sources, and we'll deal with those as well.
Great. Well, I think I will explore some of those you mentioned, but I wanted to start with the libel issue. And for that, I wanted to talk a little bit about the episode that made you famous, if that is okay. I believe that in 2016 you wrote a letter to Mr. Trump's lawyers during the presidential campaign in 2016, and that letter went viral. What happened then? Why did you write that letter, and what was it about?
We had run a story the day before that talked about two women who claimed that they had been groped by Mr. Trump many years ago. The story had been sent to me before publication. I read it. I thought it was an important story to tell. I really liked the story because it explained why the women were coming forward when they were. It's told readers that they had not come forward at the time. And so, to me, that's really good journalism, because readers can make a decision about, is this believable or is it not believable? But the story had credibility to us. We thought it should be published. Mr. Trump's lawyers wrote a letter telling us that we needed to take the story down, that it was untrue, and demanding that we retract the story. They posted that story online, so in the United States there was much attention to how were we going to respond? Would we take down the story? How were we going to deal with this? I felt it was important to write in response, and to me, it was a pretty straightforward response that this was an important story. People had a right to see it. And it was important for me and for the New York Times to articulate the values of freedom of the press in that letter. I didn't expect it to go viral. I knew that the New York Times was going to put it online because the first letter had gone online. I write lots of letters. Most lawyers' letters are ignored, even by the people you send them to. They don't, you never get a response. So it was very, very odd to suddenly see how much attention the letter was getting.
Okay, and I wanted to combine that with the fact that you said that you're still worried about libel in the newspaper, but that you don't face that much litigation around libel anymore.
Right.
So what are the characteristics of the American legal system that avails for this kind of response and that makes it the case that you don't have to face that many lawsuits around libel?
Right. And I would distinguish between our internal standards and the legal standards. Internally, we think it's very important to get the story correct. That is always our goal as lawyers. That's always our goal as journalists. When I read a story in advance of publication, I'm looking for indications that we have the story right, and I'll ask questions about what sources we used, how the reasons that we're certain that the sources know what they're talking about, what the documents show. We want the story to be right. Legally, we have much greater protection than that. And the most important part of the law deals with the limitations on the rights of public figures and public officials to bring libel suits. If someone is a celebrity, if someone is a public official, if someone is a great sports star, they have two very important burdens to win a libel suit. First, they have to prove the story is false. The burden of proof is on the plaintiff, on the person bringing the lawsuit. Second, even if the story is false, the publisher wins in those cases if the publisher did not have reckless disregard for the truth. What that means very simply is that if the reporters, if the editors believed what they were writing was true, they will win their lawsuit even if the story happens to be factually wrong. There are other protections as well, but those are the two big ones. And as a consequence, it's very unusual for public figures to bring libel suits against anyone. They know they can't win except in extraordinary circumstances. The legal fees are often very high, and so they're going to spend a lot of money to lose a lawsuit. And those things, I think, have really driven down the number of libel suits over time. Private figures, private individuals, they have an easier time, but they still face some of the same obstacles. They still have the burden of proof. They still face the costs of going through litigation. And I think as a result, and I think this is a positive development, many people think that there are better solutions than suing, demanding a correction, going online and denouncing the story, trying to set the record straight through other media online. I think that really is how the system should work. I think the fewer lawyers involved, the better when it comes to free speech.
Well, a few questions around
Sure.
around those aspects of your answer. The first thing that came to me was this doubt around the criteria that would establish that the newspaper has lived up to its responsibilities when gathering facts or when it comes to news gathering. So are there established criteria to say that the newspaper has done its job when it comes to news gathering so that he could prove or make an argument before court that the newspaper believed, or the journalists believed, the story to be true?
It would be hard to articulate specific standards, but let me break this down in looking at a lawsuit brought by a public figure and a lawsuit brought by a private individual. When it's a public figure, the test is going to be, what did the reporter and the editor think? What was in their mind? Did they believe it was true? And there are cases where the reporting simply wasn't sufficient. It did not do what it was supposed to do. And the publisher still wins because the reporter and the editor believed the story was true. I'm a practicing lawyer and a part-time professor. I think we could discuss whether that's really the proper balance.
Okay.
If I were a professor, I may have a different opinion. If I were a full-time professor, I may have a different opinion. In England, for instance, you have to show that you engaged in responsible journalism, and people will tell you that's a better standard, that should be the standard. In the United States, though, the Supreme Court wanted to create an imbalance. The Supreme Court wanted reporters to not be worried that little errors, little deviations from normal procedures would lead to lawsuits. They created an imbalance to protect free speech, free press. Go over to the other side. Now, a private individual brings a case. There, the standard is, has the reporter met his or her duty of care? Has the reporter acted negligently? And that's going to be judged on professional standards. In a case brought by a private individual, there will be experts who say, here is the accepted practice of journalism, and the journalist met it, or the journalist didn't meet it. So you're going to have much more of something that looks like the standards that are normative for the profession.
Okay, but you said that even if the lawsuit is brought by a private individual, this private person still has the burden of proof.
Yep.
That means that this private individual has the burden of proving that what was said is false.
That's correct.
So I get from that the press can bring true stories to the public, regardless of the nature or the character of the personality that
Correct.
Is being covered,
Mm-hmm.
be it a private or a public figure.
Right. There's no question that the Supreme Court was not trying to set a balance. The Supreme Court did not set out to say the right to reputation is important, the right to freedom of the press is important, and we're going to balance those two things. The Supreme Court very clearly said that the Constitution protects the right to publish, the right of a free press, and the right of free speech, and that means it is going to be the important value to pursue. And that if that means that individuals may at times not have a legal remedy, that is the price we're going to pay to have a free press. That was the calculation. It is possible for private figures to win libel suits. Occasionally, public figures win libel suits, but they're rare cases because that is a very high burden of proof. The thing I would come back to is that the Supreme Court also saw that in creating this imbalance, they had expectations of the standards that journalists would follow. And they were willing to trust journalists to, in most cases, do the right things to get at the truth. And that was an important part of the calculation. The Supreme Court did not want journalists to self-censor themselves for fear they were going to be sued or their employer was going to be sued. But there's a certain wisdom there, which was certainly true at the time in the 1960s when these decisions were decided, which is that a newspaper's ability to survive financially is by having a good reputation. for having the truth. They have an interest in getting it right. And I think the Supreme Court said, if that's so, we don't need the law to tell them to do it.
Okay. But then what would be, if there is any, the status of other competing interests that could be opposed even to true stories? For instance, privacy.
Right. Yeah. This will not surprise you that those cases are rare. Those the right to bring cases based on other theories are almost non-existent. In the United States, the Supreme Court hasn't really decided privacy, but it is a matter of state law. And in most states, a person who sues for invasion of privacy, who says that story's true, but that was private information, will lose if the publisher can show there is any public interest. As a result, it's very rare for someone to win a privacy suit. In New York State, the courts will not even recognize that as a claim.
Okay.
You cannot bring that claim. In other states, you can bring the claim, but the plaintiff has to show that there's no public interest. It's a very high standard because the courts have said if it's in the paper, if it's on television in a news show, that's proof that it's of public interest. Again, whether that's the right calculation, the wrong calculation, I've approached this as an advocate for a free press, so I accept that. I think that's actually a positive development. Occasionally people will argue that they were emotionally distressed. The story was true, didn't invade my privacy, didn't hurt my reputation, but it was just distressing for me to see it. And the Supreme Court has said, if the story has public concern, is of public concerns, public interest, that claim must fail. The plaintiff cannot win on that. And these are hard cases. The last time the Supreme Court addressed this particular issue of emotional distress, there were crazy religious protesters who have very strange views who were protesting at a funeral of a young man who had been killed in war in Iraq. And I can't even begin to explain how crazy the protesters' ideas are, but they believe that God is punishing the United States for having gay marriage by allowing soldiers to die. And it's very heartbreaking to think that they are exploiting somebody's personal tragedy. The soldier had nothing to do with any of that. His family had nothing to do with that. And the Supreme Court said they had a right to speak, and even if it caused emotional distress, that did not outweigh their free speech rights.
Okay. I wanted to explore a little bit this idea of the government's trust on the press. I believe that in a lecture you gave at Williams College, if I'm not mistaken, in January 2017, and in brief conversations we had before this interview, you mentioned a divide between media landscape 1.0, or old school media law, and on the one hand, which concerned traditional way of producing and consuming news, and the new problems related to new structures of information production and consumption. Could you unpack this a little bit, or this difference? What would be the 1.0 media law, and what are its assumptions? And what is the novelty about contemporary ways of producing and consuming news that would affect, or could affect, media law?
I spoke at Williams 2 years ago, so after 2 years I now know how to explain it better. So I'll try. And it's actually how I start my media law class at NYU and at Harvard, by focusing very much on this issue, which is the law was set in a certain period, and now the media has changed so dramatically in the current period. The easiest one to think about is in terms of the right to publish classified information, the right to publish secret information. The great case on that was the 1971 decision in the New York Times case, where Daniel Ellsberg had provided a secret history of the Vietnam War to the New York Times. It was classified. No one was supposed to disclose it. It came to the New York Times. The government tried to stop publication, and the Supreme Court said the government did not have the power to stop the New York Times from publishing those secrets. Many of those decisions talked about we have to trust the press. We know the New York Times will live up to its responsibilities to society and not publish recklessly. And that was the view that made it easy for them to make that decision. Was there was an established press. The press had ethics, had a sense of responsibility, had editors. It was part of the American fabric. And they didn't doubt that the New York Times was going to do what it felt was in the public interest. People may disagree with that, but there was going to be that consideration. Fast forward to the leak of classified information by someone like WikiLeaks or someone like Julian Assange. They have no editors. They have no investment as an institution. They have the ability to push that information out, if they choose, in WikiLeaks' case, through their own publishing platform, if you will. They're not in the United States. Does that rule still make sense? That rule that said the government doesn't have the right to stop a publisher from publishing information made a lot of sense when it was the New York Times and other powerful media who were the ones that were going to get that information and decide to publish or not. But you also see it in terms of libel. When the Supreme Court decided that a public figure could only win if a libel suit, if the public figure showed that the reporter and editor had reckless disregard for the truth, they envisioned a paper like the New York Times, where there would be a serious attempt to get at the story, and editors would be considering whether it is true, and all those safeguards would be there. And if they happened to get the story wrong, that was okay. That was part of the price of freedom. But they could rest comfortably that there was going to be responsible journalism. Now you see libel suits over tweets, and the same standards apply. There was a famous libel case brought by a popular singer who tweeted that her lawyer must have taken a bribe. And the lawyer didn't take a bribe, the lawyer sued. The lawyer was held to be a public figure, so the lawyer had to show reckless disregard for the truth. And the singer said, I didn't know if it was true or not, but I didn't think it was false, and that's enough. She said it, she didn't have any evidence, but she believed that it could be true, and that was enough. I'm not sure that people feel very satisfied with that when the scheme was created with this view of editors and reporters taking their job seriously, and now you have people who sit down at their cell phone and type up something and shoot it out. And is it true? I think it's true, but I don't really have evidence to prove it.
But do you believe that this new situation could seriously put some pressure on the legal standards in place in the United States nowadays?
We haven't seen a lot of that. Where I think there will be pressure is within the current scheme to change the standards within the current scheme. In other words, I don't think that we're likely to see actual malice, reckless disregard of the truth cease to be the standard. I think that there is some pressure on who's a public figure and who's a private individual. The judges in the United States have often been very lenient in saying somebody's a public figure, and that, of course, makes it easier for the publisher to win. I would not be surprised to see more decisions where people who look like public figures are declared to be private individuals to try to get greater balance, if you will, between the right of reputation and the right of free speech. But I think in part the system has gone on so long and there are so many decisions, it would be very hard to overturn the fundamental parts of the law. The thing I would say that also needs to be factored in here is that today people have the ability to use other remedies other than the law in a way that we've never seen before. If somebody disagrees with a story in the New York Times or thinks it's wrong, that person can go online and be heard and can provide a countervailing narrative, say that story made these mistakes and here's the actual truth. And I think that's important. And I think that has helped give people a remedy that they didn't have before. I think also that for publications like the New York Times, which still applies traditional standards of journalism, the internet has helped out as well in this way. If we have something wrong, we're going to correct it, and we're going to correct it online. And that correction is going to be much more powerful than it was in the old days. In the old days, the story is wrong on day one, somebody complains on day two, reporters and editors look into it, oh my God, we made a mistake. They give it to another editor, that editor decides, oh, we need to run a correction. 5 or 6 days later, there's a little correction that appears in the newspaper. No one's ever gonna see that, okay? Now, when we do a correction, we post it with the story, and so as long as that story is online, and we think that's gonna be forever, that people will see, oh, the New York Times made a mistake, they corrected it, got it. And I think that in the end, if what we really want is to make sure people have accurate information, that's a better solution than spending days and weeks and months and years in court.
Okay, great. I also wanted to touch upon another legal issue that is gaining relevance recently and is related to libel, I believe, and privacy issues, which is the so-called right to be forgotten.
Yes.
This right has been recognized by the Court of Justice of the European Union in the Costeja case, if I'm not mistaken, in 2014. I wanted to ask if there is any mobilization in the United States pushing for the recognition of this right, if it has been recognized at any point or not, and if you believe there is a chance it will, if it hasn't, and in which terms?
We could have a very short answer, which is no to all of that, but I'm going to explain. Even in Europe, even in the decision against Google Spain that you mentioned, the courts recognized a journalistic exception so that newsworthy information on news sites can continue to be displayed by those news websites, even though someone may have the right to be forgotten, as it's been called. In Europe, as you know, the right to be forgotten has really been aimed at Google more than anyone, and ultimately it's the right that when someone searches with your name a story that's outdated or it otherwise creates a privacy problem will not be returned in that search. The story still exists on the website of the original publisher, but when somebody does a Google search in Europe using the individual's name, that story's not going to come back. It has not been recognized in the United States. I think it's generally accepted that such a right would violate the First Amendment. Newspapers like the New York Times have the right to maintain electronic archives of stories, and there is no right to come in and say that story needs to be taken down or not returned in a search. It's a controversial issue. We get a lot of requests from people who see a story about themselves from many years ago and they want to take it down. Some of them have very sympathetic stories. They have committed a crime or gotten in trouble as young people and now they're responsible adults. They don't like the fact that story still comes up. Some of them are less serious in my mind. The most common request is somebody who wants their wedding announcement taken down.
Really?
Yes, because they don't want people to know they were married to some bum before. Somebody once said to me that her children had just learned to read, and she and her husband, her new husband, had not told the children that she'd been married before, and she didn't want the children to know that. That seems like a family problem to me, not a First Amendment problem. But we've taken a position that we're not going to take down upon request stories. We believe that our archive should reflect what we published historically. Where we are seeing the derivative idea, the derivative concept of the right to be forgotten, is in laws that are requiring government agencies to keep information secret. This basic scheme in the United States is that government has many, many rights, has great power to keep things secret. That's probably the better way to put it. They have great power to keep things secret, and the press, once they get those secrets, have the right to publish them. So the focus in the United States when it comes to privacy has been with legislation designed to try to make sure that government information does not become public. Most common one in the United States, most common one in the current trend, has been to have laws that make secret past convictions of minor crimes. This typical proposal would be that if someone was convicted of possessing marijuana or some other minor offense, that after 5 years, if there has been no further criminal problem, that record is permanently sealed. It's not available. Citizen asks for it, a journalist asks for it, the government can't give it up. Now, if a government official violates the law and gives it to the press is free to publish it. The government official may be in trouble. But that's how privacy is really being addressed, more as something the government has an obligation to do, as opposed to something that the press has an obligation to do.
And does the press sometimes counter that with freedom of information actions?
It could, but the Freedom of Information Act at the federal level and the various state ones all say that if information is exempt from disclosure by some other statute, the Freedom of Information Act doesn't apply. So if they pass laws that say criminal records can't be revealed, arrest records can't be revealed, the Freedom of Information Act is powerless to get at it.
So a question related to freedom of information. I believe that the New York Times is one of the leaders in bringing freedom of information lawsuits and trying to get relevant information for public display,
yes.
or publication. What are the main difficulties that the newspaper and its journalists face in this endeavor?
And we do bring a lot of libel suits. If you got frequent flyer miles, I could fly around the world. You got miles for bringing suits. Let me just give a little bit of background here about how the Freedom of Information Act works, because that helps understand what we're up against. The law says, very simply, any citizen can request information, and a government agency within 20 days has to either give the information, the documents up, to the citizen, or state a legal reason for not doing so. And the Freedom of Information Act has a variety of exceptions that allow the government agency to withhold information: national security, law enforcement investigation, undue invasion of privacy, and various other things, national security, for instance. If the citizen is unhappy with that answer, the citizen can go to court and try to get a judge to say, the government's wrong, you do deserve the information. That's where our practice has now become focused, is that that system of requests has in many ways broken down. There are long delays despite what the statute says. There is a tendency by the agencies to find exceptions apply, that They will very easily say, oh, that involves privacy. Oh, that involves deliberative communications, decision-making communications. That involves a law enforcement investigation. This is not surprising. If you are a government worker, turning over information probably is going to be bad for your agency. Okay? Agencies are very happy to turn over good information about themselves. They're very reluctant to turn over bad information. So there's a natural tendency in any bureaucracy to say, we don't want to turn this over. So we sue, and it's been a struggle for a couple of reasons. One is, over time, the courts have been very sympathetic to the agencies, and so the law is not as strong as I wish it were in favor of disclosure, in favor of transparency. The second thing is that many of the cases we're bringing are really cutting-edge legal issues under freedom of information. We're going after very difficult information, national security information, information from law enforcement investigations, and we're really arguing that the exceptions in the law should be narrowed, and this information is important. That makes it hard. As critical as I am of the Freedom of Information Act and how it's actually worked out over the last 50 years, I do think it's important to say that I think it has created a culture of openness. So routine documents are never a problem. Government agencies understand that they have to provide them. And I think that has benefited routine journalism, that is day-to-day journalism. Nobody has to fight over, can I get a record of who the police arrested last night? Can I get a record of the city's budget? Can I get a document that shows what was discussed last night in the legislature? Those kind of things are going to be available. But the actual law itself has not worked as well as I would hope it had.
Okay. One last issue that I would like to address is the one related to fake news and the fake news debate. There is a lot of discussions going around the world, I would say, on how to control it, if we should control it, how to deal with it, so that we could ensure or at least promote quality information and healthy public debate. How is this debate being conducted or run in the United States, and how has this, if it has, how has this discussion affected the press and journalists' work in general?
Right after the election, I was on a panel at a law school, and one of my fellow panelists was a Columbia University professor who had written a book on fake news in the 19th century, which I don't think many people had read, and suddenly she was much in demand because everybody wanted to know about the history of fake news. And it's important to remember that fake news has been around for a long time. It's not a modern idea. In the United States, fake news has been treated as lying outside legal control. That under the First Amendment, people can make things up, things that are untrue, and the First Amendment protects them. It's not limitless. If someone's making something up to steal money from somebody, to defraud somebody, that's a problem. If someone is lying under oath, that's a problem. But generally speaking, if someone is simply making up a story about Hillary Clinton or Donald Trump or me, the courts have recognized there's a First Amendment right to do that. And it's consistent with the free speech, free press tradition in the United States, which believes that it's up to readers and viewers to exercise critical judgment, ask critical questions, and it's up to the media and individual citizens to speak up and say, that's not true. There is a belief that truth will emerge in the marketplace of ideas and doesn't need courts and lawyers and laws to tell them what the truth is. I understand that's a very unsatisfying answer, and I think most of us go through life knowing that people are misled. People are sometimes lazy in their thinking. But I'm worried that in places where laws are being passed, that the cure is worse than the disease. The United States has spoken on this and said, we don't trust government, we trust the people, and it's up to the people to police the marketplace of ideas, including about fake information. It's a long process. It's not an easy process. I understand why people want to pass laws to try to limit fake news. My concern is that in many of the countries where we're now seeing fake news laws being passed over the last year, Indonesia, Turkey, the Philippines, Egypt, they're not really about the truth. They're about the people in power using those laws to silence truths that they don't like. And that concerns me. I think that that is a very, very bad development. And I feel fortunate the United States has taken a different approach on it. I think there's one other thing to take into consideration, and that is, does fake news really work? And if it really works, what is its effect? I think the research suggests that it actually has a very limited effect. It's very easy to get excited about it, and I certainly talk about it a lot. But when I look at the research, it certainly doesn't work like we would think it would, at least not in most cases. Fake news goes up, somebody believes that that's not really what's happening. Fake news goes up, someone who already believes bad things about the subject of the fake news, it reinforces the point of view. But there's much more research to be done on this, and I think that the research has been inconsistent. I'd be very interested to see when there are better studies about the effect of fake news on voters.
Great. Well, that was terrific. If you allow me, I would only want to pose one last question. In your perception, what do you believe are the main challenges of the press in this, I don't know if we could name it, media landscape 2.0?
Yep. I think that the major challenge is to survive financially in a digital era. It's very difficult to survive. Many small newspapers in the United States are in desperate shape. They simply don't have the resources. A lot of that has to do with the advertising market disappearing for newspapers. Local newspapers used to be the only way that local merchants could advertise. Now local merchants have their own websites. They can work with other websites. And so financially, there's a great deal of pressure. I think in terms of content, it's a challenge to continue to convince the public that the truth matters, that we are doing our best to get at the truth. That idea is under a great deal of pressure. And so I think that it's imperative that the mainstream media continue to not only pursue the truth, but make sure the public understands that there's a difference between what they read in the New York Times and what someone has thought they knew on Facebook. I think also, finally, that the emergence of huge social platforms like Facebook challenge reporters to get at reporting on Facebook, Twitter, other platforms. They are now powerful players in the media and powerful players in politics, and they should be scrutinized and monitored and written about just the way big government is. And in the United States, that's hard because they're private companies, and private companies do not have to share information, and that makes them difficult targets for reporters. But I think the public really needs to understand what Facebook is doing and how it's doing it, And I think that's going to take a real effort on the part of reporters to get at the truth of that, but nothing could be more important right now.
Okay, great. I thank you very,
Thank
very
you.
much for giving us this wonderful interview.
Thank you.
It was great.